1964 1 SCR, page number is not mentioned, but 371. You can correct. Page 169, citation. 371. May I? I'm sorry. Look, this is a judgment by 6 honorable judges bench. The legal sovereignty of Indian nation. Your Lordship, guess, my Lord Justice called, my Lord, para 101.
101.
The judgment is, my Lord, State of West Bengal versus Union of India.
Yes.
Legal sovereignty of the Indian nation is vested in the people of India, who, as stated by the preamble, have solemnly resolved to constitute India into a sovereign democratic republic for the object specified therein. The political sovereignty is distributed between, as well as we will presently demonstrate, the Union of India and the states with greater weightage in favor of union. Kindly come down, my Lord, to para 35 of the judgment, only the underlying portion. There are no independent constitutions of the states apart from the National Constitution of Union of India. Chapter 2, Part 6, from Article 152 to 237 deals with states, the power of legislature of the states, the power of executive and judiciary. What appears to militate against the theory regarding the sovereignty of the state is the wide power with which the parliament is invested to alter the boundaries of states and even to extinguish the existence of a state. There is no constitutional guarantee against alteration of boundaries of the state. By Article 2 of the Constitution, the Parliament may admit into the Union or establish new states on such terms and conditions as it thinks fit. And by Article 3, the Parliament is by law authorized to form a new state by redistribution of territory of a state, or by uniting two or more states or parts of states, or by uniting any territory to a part of the state, increase the area of any state, diminish, etc. But then 4 lines from thereafter, Parliament. The word starts with Parliament. Parliament is therefore by law invested with authority to alter the boundaries of any state and to diminish its area so as even to destroy a state with all its power and authority. That being the extent of the power of Parliament, it would be difficult to hold that the Parliament, which is competent to destroy a state, is on account of some assumption as to absolute sovereignty of the state, incompetent effectively to acquire by legislation designed for the purpose of property owned by the state for government purposes. Then next is, my Lord, again, Babulal Parate is 5 judgment. But Babulal Parate, this is different, my Lord, not that 19(1)A judgment. That is also Babulal Parate, my Lord's recollect, my Lord, freedom of speech and expression. Lord, here views, my Lord, the assembly's views were taken from Bombay Assembly for ABCDE areas. And when the Reorganization Act, Act was passed, Lord, it was some additional areas were also, Lord, therefore that was under challenge. We proceed now to consider these contentions. It is necessary to state at the outset that our task is to determine on a proper construction the true scope and effect of Article 3 of the Constitution with particular reference to second condition laid down by the proviso thereto. We bring it to our task such consideration as are germane to the interpretation of an organic instrument like the Constitution, but it will be improper to import into the question of construction doctrine of democratic theory and practice obtaining in other countries unrelated to the tenor, scheme and words of the provision which we have to construe. Lord, kindly come to the later part, my Lord. Article 1 of our Constitution, Lord, somewhere in the 10th line from bottom of 170. Does your Lordship get me?
Yes.
Article 1 of our Constitution says that India is a union of states and the territories thereof are specified in the schedule. There is therefore no difficulty in understanding what it meant by expression state in Article 3. It obviously refers to states in the first schedule, and the legislature of state refers to the legislature which each has under constitution. That being the position, we see no reason for importing into the construction of Article 3 any doctrine, consideration of the sanctity of rights of states, or even for giving an extended meaning to the expression state occurring therein. None of the constituent units of Indian Union was sovereign and independent in the sense the American colonies or Swiss cantons were before they formed their federal unions. The Constituent Assembly of India, deriving its power from the sovereign people, was unfettered by any previous commitment in evolving a constitutional pattern suitable to the genius and requirement of the Indian people as a whole. Unlike some other federal legislatures, Parliament, representing the people of India as a whole, has been vested with the exclusive power of admitting or establishing new states, increasing or diminishing the area of an existing state, or altering its boundaries, the legislature or legislatures of the states concerned having only the right to an expression of views on the proposals. It is significant that for making such territorial adjustment, it is not necessary even to invoke the provisions governing constitutional amendments. Then, my lord, Raja Rampal, only one line, my lord, I'll now coming down to one line, my lord, kindly, my lord, appreciate. It says India is an indestructible union of destructible units. Raja Rampal, my lord, again, 5-judge bench. Law, my lord, I am pointing out. I am not pitching that argument that high, my lord. We have what we have done is as a temporary measure, as it is clear from day one, the parliamentary debates, that we have created two units, namely two union territories, and one union territory is with legislature, the power vested with the power of police with the center, because of the very peculiar nature of the situation arising since decades. Rest everything they have, what state has.
Pointed out two instances where it has happened. First was Punjab. That was a very peculiar problem. Punjabi Suba movement, etc. More or less everybody was agreeable, probably it could not muster through the legislative assembly.
No, there was no assembly.
There,
It was during governor's rule.
no, I understand that, but earlier it could not muster through the division of Punjab between Haryana and then parts of Punjab going to Union Territory first, even Himachal Pradesh, then Himachal Pradesh itself becoming a state. And then probably Cochin and Travancore is the other example which was given. The third is this. This is a way, because once you suspend the proviso, then virtually the power of the state governments are taken away. The representation of the state is represented by the will of the people of the larger country.
Correct.
Can lead to
that is my lord, touched upon in Bomai, SR Bomai. My lord, please come to page 173. Even this question was, my lord, considered in Bomai judgment. We read Bomai judgment for a different issue, but this was also one of the consideration, one of the factors which fell for consideration of the court. Page 173. where the court considers what is the scope and ambit of the state's views. That's why I'll, rather than paraphrasing, I'll read. Lord, kindly see SR Bromai, para 108. Lord, para 108, my Lord Justice, called page 173. I have quoted SR Bromai. Lord, last 4 lines on that para. But I'm trying to rush, my Lord, so that I can finish. Your Lordship gets on a conjoint reading, my Lord Justice Khanna gets on a my Lord Justice Suryakant and yes. On a conjoint reading of these articles, it becomes clear that Parliament has the right to form new states, alter existing states, or the name of any existing state. Thus, the Constitution permits changes in the territorial limits of the states and does not guarantee their territorial integrity. Even names can be changed. Under Article 2, it is left to Parliament to determine the terms and conditions on which it may admit any area into the Union or establish new states. In doing so, it has not to seek the concurrence of the state whose area, boundary, or name is likely to be affected by the people. All that the proviso to Article 3 requires is that such cases the President shall refer the bill to the legislature of the states concerned likely to be affected to express their views. Once the views of the states are known, it is left to Parliament to decide on the proposed changes. Please, my Lord, note, Parliament can, therefore, without the concurrence of the states or states concerned, change the boundaries of the state or increase or diminish its areas or change its name. These provisions show that in the matter of constitution of states, Parliament is paramount. This scheme substantially differs from the federal setup established in the United States of America. So, my Lord, it is in substance, in my respectful submission, said that it's a provision which is strict compliance is not insisted upon, provided there is a broader compliance, namely the entire nation, considering that this affects the nation as a whole. This situation doesn't affect the state only or neighboring states only. This affects the entire nation and therefore including representatives of Jammu and Kashmir. Parliament and Rajya Sabha, Lok Sabha and Rajya Sabha have representatives of Jammu and Kashmir. Lord, these are my judgments on 3 and 4. Would your Lordships like to have a bird's eye view of the Act? All right. Lord, Volume 3, documents, page 112. I won't take more than, my Lord, 5 minutes to do this. I am, my Lord, tempted to show this because nobody has shown, which could not have been my objection, but without showing several statements were made that we are reduced to nothing, everything is taken up. Therefore, my Lord, it is my duty to point out just bird's eye view, my Lord. Page 112. Volume 3. Volume 3, document volume 3, my Lords. Page 112. Lord, please see definition, assembly constituency is defined 2C. It has all attributes of a state. It is state with UT with legislature, but all attributes of a state. Assembly constituency, your Lordship gets 2C. Am I with your Lordship? Yes. Then election commission 2D, then 2G, my Lord, on the next page, 113. 2G, legislative assembly, J, population ratio and union territory. Please, my Lord, see the formation of union territory of Ladakh without legislature. Then, my Lord, formation of union territory of Jammu and Kashmir with legislature. Correct, my Lords? Then come to, my Lord, page 114. No reduction. They say that our representation in Parliament is reduced. On and para 10. On and from the appointed date, there shall be allocated 5 seats to successor Union Territory of Jammu and Kashmir and 1 seat to Union Territory of Ladakh in the House of People. Earlier they had 6. Now it is 5 plus 1, 6.
Where
Then
did you get that?
delimitation of I'm sorry.
That's section 10.
Section 10, Manoj. Manoj, the argument of Mr. C.U. Singh was that we have lost representation in parliament. Then somebody said that our seats are reduced. Manoj, Mr. Nafde said the seats are reduced. It was 6 in total. Now it is 5 Jammu and Kashmir and 1 Ladakh.